Hello, everyone, and welcome to Mayor Brown's program on navigating the brand licensing lifecycle, essential strategies, common pitfalls, and best practices. We're delighted you could all join us today for our discussion about the brand licensing lifecycle, essential legal strategies, common pitfalls, and best practices that are pivotal to successful deals and product launches. Today's program that is focused on the brand licensing lifecycle is the first of what will be a multi-part series of programming covering various topics related to brand licensing in more detail, so stay tuned for more afterwards. Before we begin, we have a few housekeeping notes. Regarding CLE credit, an affirmation form was provided to you in the registration confirmation email you received. In order to receive CLE, you must complete that form and record the code that we will announce during the presentation on the form. After the program, please send the completed form to cle-events@mayorbrown.com. These instructions will also be repeated when the code is shared. We want this program to be interactive, so we welcome any questions or comments via the chat feature. We will try to answer all of your questions either during or after the presentation. We also want to hear from you about what topics you'd like us to cover in the future. So at the conclusion of today's webinar, you will be directed to a short survey, and we would appreciate your input on the program as well as your input regarding future programming. With that said, let's get started. My name is Christine Young, and I'm a partner in Mayor Brown's intellectual property group based in Chicago. My practice is focused on everything related to the protection, enforcement, and monetization of brand and brand assets. My colleagues and co-presenters are also going to take a brief moment to introduce themselves.
Hey, this is Todd Davidovitz. I'm a senior associate with Mayor Brown, and I'm a IP entertainment and technology lawyer. I was previously the head of IP at Anheuser-Busch and worked at on some of the biggest licensing, endorsement, sponsorship deals. I also teach IP licensing and drafting at Washington University in St. Louis, and now Krista is gonna go.
Thanks, Todd. I'm Krista Cole. I'm IP counsel at Mayor Brown. I'm based in Los Angeles, and I was formerly the head of trademarks and licensing for Nestle. Did hundreds of deals, licensing deals, and really excited about this area and excited to bring this content to you today. When I was starting out in licensing 10 plus years ago, I looked everywhere for educational information on brand licensing, and I found it very hard to find. So I thought this would be a great opportunity to get people started in the area. And then, as Christine said, we'll have a series to do more and more education on brand licensing. Let's see if I can advance the slide. So for today, we're going to set the foundation first for you and talk a little bit about what is brand licensing and why your businesses would want to license. We're going to talk about the brand licensing life cycle, AI considerations for brand licensing, and then we'll end with some recent licensing cases. So setting the foundation, what is brand licensing? I equate it to a lease or a marriage where two parties are coming together. The brand owner is essentially leasing their brand to another party to use, reproduce, and distribute their trademarks and other brand related assets. So why would a company want to, a brand owner want to license and a other party want to be the licensee and take a license? And importantly, according to a Licensing International global study from 2024, sales of licensed merchandise and services have reached $356.5 billion in 2023. So that's a lot of opportunity for brands to make extra money. And the global licensing industry is growing. It grew 4.6% in the last year. So licensing can help brands expand their category presence, help brands grow and reach a wider audience, drive consumer engagement, generate incremental revenue, borrow competencies where a brand owner may not be able to make a certain product, another party can make it for them. And it can also strengthen your trademark rights, all of these things which we'll talk about in more detail. So we're gonna just look at the types of brands quickly, so you guys all are grounded for the rest of this conversation of really what we're talking about. And there's several types of, sorry, not types of brands, but types of licenses. And there's several types of licenses that we work on a regular basis. And the first one is co-branding. This is really just to understand the terminology, but co-branding is where you have two brands that are coming together. So you see Dr. Pepper did a co-brand with Krispy Kreme. You have Lyft doing a co-brand with MasterCard, and you have Starbucks doing a co-brand with Marriott. So the two brands are coming together and benefiting from each other's goodwill. Then you have the mono-branded or the fully branded type of license, and that's where the product has only one brand on it. Cover character licensing as well. That's where you, mostly with the entertainment studios. This is one that I worked on recently, and it just launched with the launch of the Deadpool Wolverine movie recently, and DiGiorno licensed in Deadpool, put it on its packaging. So we've got character licenses. Entertainment studios are really fun to work with, and very well received product, super exciting. NIL licensing, name, image, likeness, very fun area. If you haven't seen Love Island, it's very addicting. So the latest season had Cordell, which is the character that's on this Cheez-Its box. And in one of the very first episodes, he was talking to his future girlfriend about what his long-term goals were. And he said in this initial episode, his long-term goal was to be a sponsor or be involved in sponsorship. And she pushed him, "What do you mean by that?" And he said, "Well, I'd like to do a Cheez-It sponsorship." And sure enough, just very recently, Kellogg snagged the NIL rights for Cordell and put him on the front of the box. So if your brand teams are watching closely, you can find some really good opportunities out there that come pretty organically. And then there's branded ingredient licensing, which takes the form of an ingredient that's used in the product or just a flavor of the product. So here's an example with Sour Patch. Mike's Hot Honey does a lot of this. And there's a lot of other branded ingredients that are pretty popular in the food area. And the last one of a type of license is experiential. You have, this one is Taco Bell doing a retirement community, but people have probably seen with the launch or the release of Beetlejuice. There's some experiential Beetlejuice pop-ups. Stranger Things has done a lot of experiential pop-ups. So those are very exciting for the brands and help with the brand awareness and brand growth.
Thanks, Krista. So now that we've set the foundation for what we're talking about when we say brand licensing and given some examples of its applications in the marketplace, we're going to delve into the licensing life cycle and discuss some of the pitfalls and best practices along the way. So brands are very visual, so we thought the best way to do this was to provide a visual of the brand licensing life cycle. The life cycle starts along the left-hand side with our strategy development. And that's the first stage, your brand evaluation, your goal setting, and assembling your team. The next step after that is identification of your partners, including the research and diligence. In the middle there, we have memorializing the deal. It's not necessarily in order, but it's sort of the glue that holds everything together. Once you've identified your partner, you start memorializing your deal with preliminary negotiations and NDAs and whatnot, as well as eventually the final agreement. Once the final agreement is signed and the parties have agreed on the terms of the arrangement, the production implementation phase begins, followed by your launch plans and marketing strategy and execution, and then finally evaluating whether you're going to continue or exit the deal, and how you're going to do that and what that looks like going forward. We have a little acronym here. It's a simple strategy. This is what your lawyers, you see the first letter of each word on our cycle. This is what the lawyers, both outside and inside counsel, are supposed to do. They're supposed to help you make the process simple. The deals can move quickly And in the process, it's important to be organized and intentional. So in the end, you have a deal that works for the business and that's legally sound. This goes for both sides. On the licensee side, you want to make sure the deal fits with your processes and procedures and goals for the products and services and their reach. And you want to make sure that you're able to comply with the agreement going forward. On the licensor side, you want to make sure that your marks are protected and the quality control and various provisions work for you to accomplish your goals associated with the licensing endeavor and expanding and promoting your brand.
Do you want me to move forward, Christine?
Yes, please.
Okay.
So the first stage of the cycle, developing your strategy and starting the conversation. The first step is knowing what types of licenses you want, and that includes the scope, meaning products and services. Do you want to expand your brand into new categories of products and services, reach new audiences, reach existing audiences in a different way? The geography, where do you want the products or services to be sold or offered? This goes for both the licensee and the licensor side. Identify the key brands and categories. If you're a licensor, especially, identifying who you might want to partner with and what categories you want to be in. Also making sure that once you've decided on this, that your trademark rights match up to what you're looking to do. And that means clearing your marks that you intend to license for new applications and geographies if they're not already protected, making sure that they're available for use, and then going ahead and getting out ahead of the deal and securing either applications or registered rights depending on the country and what you need to proceed with use in those jurisdictions. And finally, assembling your team. There's many different facets of the business that are involved in these deals. It's the legal team, of course, it's your outside counsel, your in-house counsel, but your quality control team, your finance teams, your supply chain teams, your insurance and your risk management teams, and your tax teams, making sure that they're all on board and know what's going on, and that you're going to need their help, support, input, feedback in order to move a licensing deal forward.
Yeah, and one thing about securing the rights, so everybody thinks about the trademarks, right? So you know what the taglines are going to be, you know what the brand is going to be, and you want to make sure to lock that up and to clear it, like Christine said. But one thing people don't always think about are the domain names. And I personally had a situation where there was an entire execution ready to happen. There was a lot of money put into it. And long story short, someone bought the domain name, there was a leak, and someone bought the domain name, and they essentially held the project hostage. This happened on a Friday. We had to execute on a Monday, so it was a lot of craziness. So remember to secure the domain names and obviously have NDAs in place.
Yeah, and I think also, Todd, adding on to that is not just the domain names, but the socials. And are there any NIL rights that you need? So looking at everything that you'll need to acquire the license to, or give a license to execute on whatever that strategy is.
So here's just a best practice to encourage all of the stakeholders, once you've assembled your team, to think through the licensing approach and address as many unknowns as you possibly can up front, so that you can then go out and present an aligned position to your licensing partners. Know what you must have, what you can't agree to, what some sticking points might be, so that when you approach licensing partners or start talking to them, you sort of know where your bounds are. It's going to make the negotiations go a lot quicker.
Okay, identifying your licensing partners. This is just, we wanted to talk about, how do you find and how do you help your business find the right licensing partners and ensure that they're the correct partners. So first, I've had a lot of marketers come to me and say, we'd like to do a deal with X, but we don't know how to get in touch with them. So I think, and this is just me, trying to figure out how do we get in touch with someone. I have used LinkedIn. I find LinkedIn to be a great resource to get through to the brand owners. I also have used the USPTO and looked up the the correspondent on the brand owner's trademark registration and gone straight to the lawyer. I find that to be a great way to get through to ultimately to the marketing teams, is reaching out to the trademark lawyers on the brand. And once you have your, and actually there's also a lot of other ways for finding partners, but there's Licensing International, which has an expo every year. You can come to your outside counsel, who has a lot of contacts, especially your trademark outside counsel has a lot of contacts with brand owners. So there's a lot of ways to get in touch. And if anyone that's listening needs any help, you can always reach out to us because we're pretty good at that and have a pretty good database. So once you have your licensing partner identified, you're starting to get in touch with them and talk to them. You want to perform your due diligence on them, and you want to encourage your business to do the due diligence. Like we were just talking about, do they have trademark rights? What rights do they have? Are they financially secure? Do they have a strong executive leadership team, or could that change in the future? You really want to know who you're getting into this partnership with. So do that due diligence on the other side, and know as much as you can about them. And that, I think, is a shared task between legal and business to get the information. So the conversation is starting with that partner that's been identified. Don't forget the NDA. And that's always something that I advise the business to do first, is get the NDA negotiated and in place so that they can have free conversations, because you know that the business is going to share freely this information to get to a deal, and they have to share a lot of information about their own business. So we want to have that in place, and then they can discuss the deal points. What are those terms? And we typically like to do it with a deal memo so that you have a document with all of the deal points in one place. You have the pre-alignment between both parties on those deal points. And then you can use that deal memo. The lawyers can use the deal memo to develop the long form agreement. So best practice here is licensing, like I said, is like a marriage, and know your partner before you walk down the aisle. So I think I highly advise to know who you're getting into a deal with.
Yeah, and just one thing about this, I can't stress enough, just be nice. Because the reality is these deals, you might think of them as one deal. And I know lawyers in general, in-house or external counsel, outside counsel, we're sort of trained to try to get the best deal and make sure all of the terms that Christine and Chris are going to discuss in a few minutes, we have the best deal for our client. But the reality is, from the time that the deal's envisioned till the time it's executed, I can guarantee you that there will be changes and differences in needs of what the business needs. And if you have a good rapport and you're nice to the other side, it's going to make the deal much easier. So for example, there was at least one situation that I had where going to the marketing people that were in charge said, tell me what you need, what TV commercials do you need? And they said they needed only 1 60-second and 1 30-second. And I was like, are you sure? Are you sure? Yes, yes, yes. However, a couple months when it was the time for the execution, we needed another 45-second and a 6-second. And the agreement didn't say that because that was not the instructions given. However, we were nervous, but because we were nice, there was that flexibility. So just be nice for sure.
Mm-hmm. I second that. I think that making these brand licensing deals a fun project to work on between your team and the other side goes a long way, and have fun doing it. And like Todd said, the deals will repeat, and you'll work with the same licensor, or you can work with the same licensor over and over again. So that strong relationship is very important.
Yeah, and there's a very small world in this licensing world, especially if you talk about the brands that are licensing and like the companies that own the properties. So, Christine, we know a lot of these people. Feel free to use us as a resource to the extent it's necessary. But again, develop those rapport, those relationships, and it'll serve you very well in this area.
All right, so here we're on to memorializing the deal. Once you've identified your partners and you've arrived at some basic terms of how you want to move forward, this is going to be the glue that holds it all together, and probably the time in the initial stages before signing that you're going to spend the most time on. So just sort of to set the stage for how to memorialize the deal, we have some terms and phrases that are important and that are typically the most heavily negotiated. There are other terms as well. We can't cover everything in our 1-hour presentation today, but here are some big ones. Royalties. So not surprisingly, heavily negotiated terms. That is the amount of money that the licensee is going to pay the licensor in order to be able to use their trademarks and other intellectual property associated with the brand. So royalties can be structured in a number of ways, and just depending on the product, the services, what the parties have envisioned for the deal. There's a number of creative ways to structure royalties. Sometimes it's as simple as net sales on products. Other times it could be based on, for example, the MSRP of a component product that's going to be advertised along with a larger, more expensive product. For example, computer chips and computers, if the licensor of the brand for a computer chip. There's also sometimes we see a tiered approach where if certain sales milestones are reached, the royalty rate decreases after certain thresholds are met, sort of a staged and tiered approach. The guaranteed minimum payment. This is like the guaranteed floor that a licensee will agree to pay a licensor regardless of sales of licensed products or services. This needs to be a sufficient amount for the licensor to commit to the deal, and also not so high that it puts the licensee at a risk that they might owe some amounts that exceed reasonably anticipated sales of the licensed products and the royalties that would otherwise be owed under those anticipated sales. So some analysis that needs to happen on both sides in order to arrive at a guaranteed minimum payment amount to the extent that you have one that works for both sides. Licensed property. This includes trademarks, but it can also include other licensed elements associated with the brand. We have a sample definition here on the left, and there's also a best practice highlighted, not highlighted, but contained within the definition. So licensed property, as we said before, it's not only trademarks, it could be other assets associated with a brand that are going to be used by the licensee. So it's always good when there are those additional elements to the extent that you can define them and make it specific so that it's clear to the parties to schedule them. So we commonly will see schedules of like, this is included, this image is included, this graphic is included. A good thing to do so that parties don't overstep their bounds or potentially find themselves in breach when that could have all been settled up front. Licensed products. These are the products that bear the licensed property. It can also include licensed services in the definition if the licensed property are going to be used to promote services. Like, for example, a cruise line that's going to be promoting access to a licensor's resort or other experiences. Licensed services, that should all be included in the definition. We can call it products or products and services. An example definition is on the slide. And this also contains a best practice within there to make clear what is included and what is not included. So you can see in the example on the left-hand side of the slide, it says that it specifically excludes any type of product or service not identified herein. Then there's a very specific list of products. Making that specific, that it's very, very much contained to the specific list is important. It'll avoid potential disputes down the road in the case of and we'll talk about a case that involves a seltzer and a beer later and how that got confused. So just very important to define it because terms aren't always as clear as they seem when you're negotiating. You should just make sure that you're making that clear and that the parties are aligned. So failing to abide by that best practice can also lead to significant pitfalls. For example, if the licensor, the licensed property being used in connection with a broader scope of goods and services that's intended could possibly cause breach of other license agreements. It could possibly cause a third party to say, you're stepping on my rights now that this mark is being used in connection with this product or service that you are not covered for and that I have rights to, and subject the licensor to litigation. For licensees, it could lead to a breach, and a partnership that's otherwise lucrative could go sour due to the alleged breach regarding scope of use. And a licensor might not be happy if they're sued over something that a licensee did based on a misunderstanding. Exclusivity. Oftentimes, license agreements will include exclusivity provisions that grant the licensee the exclusive right to use licensed marks in certain applications, and such as product categories, geographic regions, or channels of trade. The term may also restrict the licensor from licensing to certain competitors of licensees for similar uses, or uses that are competing or closely related to the products or services that the license pertains to throughout the term. Sometimes higher royalty rates are traded for exclusivity to compensate the licensor for abiding by such restrictions. So if you're going to take the licensor's ability away from the licensor, they might require a higher royalty rate in order to do that. So the terms sort of sometimes work together. Another component of exclusivity that can be included is a right of first refusal that's granted to the licensee before the licensor approaches a third party for certain categories of products or services or geographic regions that are otherwise not included in the initial deal, but that the licensee might be interested in the future. That's primarily why it's important to be thinking ahead as both parties, but as a licensee with respect to this. Is there something we might want to get into in the future that we don't want to commit to, that we don't want to have to pay a minimum on right now, but in the future we might be interested and we would like it if the licensor would at least give us the right of first refusal. Something to think about there up front. Quality control. So that sets the standards for the quality requirements so as not to damage the reputation and goodwill of the licensor's brand. Licensors tend to set the standards for quality, and sometimes we see that the standards are general, such as no lesser quality than existing products sold under the licensed property, to be determined at licensor's discretion or some reasonable marketplace standard. Or they could be very specific, such as a hotel or resort property must at all times qualify and keep a 5-star rating based on a certain rating agency's reviews. So a lot that can be done in terms of specifics with respect to quality control, and it really just depends on the licensor and the licensor standards and what the licensee is able to commit to. And from a licensee's perspective, the licensees tend to want certainty as to what we have to meet and how that's determined, whereas licensors tend to want it to be more at their discretion. So that tends to be a point of negotiation. But I've never seen a deal gone bad for not arriving at a acceptable quality control provision. But it is contested sometimes. Audit rights. This is your licensor's right to inspect the licensee's records. It can include records and books to make sure that they're getting paid accurate royalty rates and royalty amounts on time, inspection of facilities if you have a product that's being manufactured to make sure that the licensee is using vendors that are complying otherwise with licensor standards, not violating laws and rules, human rights violations, all sorts of those things that licensor might want to inspect periodically to make sure that their brand is being used in the way that they intended and consistent with their standards. So now we can go on. The next slide here, talking about memorializing the deal some more. So we have some commonly negotiated contract terms. Here we have ownership. The first one is important to make clear who owns and has the right to use what during and after the contract term. This is particularly important to make clear who can use what during the course of the agreement and what can be used, but also after the agreement terminates. Like, for example, if you have packaging, labels, things that were created either by one party or another, but to be used in connection with the licensed products throughout the term of the agreement, what happens when the agreement goes away and the licensor gets their mark back, but you still have those materials out there that have at one point in time during the term been associated with the licensor's mark? Who gets to use it? Is it the licensee? Is it the licensor? Is it nobody? So making that clear. This is also very important with respect to product formulations. For example, in ingredient-related license deals, to make clear whether there's a formulation, it includes a branded ingredient after the deal after the deal terminates or the agreement goes away, the licensor gets their mark back. Who can use the formulation with that ingredient removed? Is it licensee? Is it licensor? Does it have to go away? Who has access to that formula? And can it be shared? Should it be kept confidential? figuring these things out to begin with is going to save a lot of potential disputes, litigation, everything down the road, fighting over rights, and potentially getting yourself walking into a false affiliation claim, an infringement claim, or a need to bring that claim.
Hey, Christine. Yeah, and this is really important when it comes to these terms. So these are headings and are important terms, but I will tell you what is standard and accepted is very, very different when you talk about the different types of licensing deals, right? So for example, if you're licensing a property for a certain like on box execution or whatever, you're not gonna own, you know, HBO's IP or Disney's IP. That's just not gonna happen. And the same is true with approvals, right? Approvals could look vastly different, right? If you hire a third-party company to do something, or you're licensing a trademark for a standard licensing deal, the approvals might not be unreasonably withheld or whatnot. But you have to understand sort of what industry, what's accepted when you present these deals, because also you don't want to look overly aggressive, but you want to be a person who's reasonable and understand to get from the get-go what you can get and what makes sense.
Yeah,
And
absolutely.
I think that a typical approach to this on the IP ownership is that each party will own what they're bringing in. And that's how I like to see it. If, you know, when it becomes an issue, is we just divide it up. What you bring to the project, you own. And when the project ends, you take back what you brought, and the other side takes what they brought.
Yeah, that could definitely be the case. But if you're hiring a third party, let's say manufacturer, to create some type of a new product that's licensing your ingredient or whatnot, it might be a little different depending on who owns that new product and whatnot. So
yeah, so definitely a lot to consider based on the nature of the deal and who's bringing what to the table, and whether anything new is being created. That tends to be where the debate comes into play most often. As far as the subcontractors go, like Todd just mentioned, so to the extent that you're using any vendors or contracts who are going to support the licensing deal, whether it be they're going to manufacture the product, they're going to manufacture packaging, they're going to create other materials, it's important prior to finalizing the license agreement, address the subcontractor obligations early on in negotiations and agree on those requirements. Licensees who drive the subcontractor relationships should come prepared with any existing subcontractor agreements or requirements to help streamline the negotiations and hopefully get the licensor on board with what they already do, the parties that they already work with, and what they intend, how they intend to use the subcontractor and under what terms for that agreement. And the licensor might have input as well, or at least say, you know, that's fine, but this is going to roll into our audit, our audit rights. We're going to have the right to audits, and you know, we would like your sometimes we would like your subcontractors to also sign on to certain things. Maybe it's confidentiality, maybe it's other obligations, but taking care of that early on, especially if you're in a situation where you might need your subcontractors to get going before a deal is actually signed, with the understanding that, like, if the deal isn't signed, the products don't launch or the services don't launch. But getting that all taken care of up front, so that it's possible that you can maybe even move quicker than the signing of the deal to at least get things underway. So once the deal is signed, the subcontractors are ready to go, and it makes the launch a little bit quicker. As for the term of the agreement, important to just think about what kind of term makes sense in terms of the products and the sell-off periods that might be needed. If it's a product, you probably need to think about a longer phase out than if it's a service. But it really just depends on what it is and how much market penetration you're going to have, and things of that nature. Licensors may insist on no right to renewal if certain sales thresholds are not met. So it's also important to think about that in the sales thresholds as a licensee, what you think you're going to meet, and like if you really think that this is something you're going to want to continue, maybe trying to loosen up those sales thresholds to try to minimize dispute over renewal at the end of the contract term. Your channels of trade and distribution, consider where you want to sell during the term and after the sell-off, or during the sell-off period. Expanded channels allowed during the sell-off period, for example, like the ability to donate product, will certainly speed up sell-off time and maybe make things easier, so that you're not disposing of a lot of product if that comes into being. So just thinking about how you would want to sell off the product and as quickly as possible if needed, and making sure that that's specified in the agreement. So the right of first refusal or negotiation, we already talked about that, so I won't spend too much time on that here. Approvals. Licensor may require approval of, we see this done in a variety of ways, but sometimes licensors will require approval of all materials prior to launch, or licensee might have more leeway so that so long as the licensed property is displayed as provided and materials are otherwise similar to some examples that licensor has previously approved, their licensee can just freely go forward with that. And another thing to think about is like if there are strict approval requirements by the licensor, consider the timing of the approvals, and what you want that to look like and what you want the licensor to commit to in terms of timing of giving the approval, so that as a licensee, you're not hung up, but also as a licensor that you have enough time to review and make decisions. So the venue selection for disputes, it's not the funnest part of the agreement or the deal, but you should consider where you want to be if a dispute arises and the parties find themselves in court. Do you want to be in arbitration? Do you want to be in court? Do you want arbitration, mediation? Do you want the ability to seek injunctive relief? On the injunctive relief piece, we commonly see licensors, maybe a split deal where we want to be in mediation or arbitration because we don't want to be just arguing in a public forum in front of everybody. But we also, as a licensor, want the ability to seek injunctive relief, especially if there's something related to use of our marks that's damaging our goodwill. We want the ability to stop that. So just considering what the nature of the deal is and how you would want to resolve disputes could be really helpful. You should also really consider your forum. Like, for example, in NIL deals, there are certain forums that are very favorable to celebrities and whatnot, and that you might not want to be in those forums. If you're a licensee, you might want to be in a more contract favorable jurisdiction versus a person celebrity favorable jurisdiction. So considering who you're dealing with and where you might want to be, and that's likely in those scenarios, there's some middle ground that can be reached. As for enforcement, the best practice is for each party to control enforcement of their marks and other property, but there are usually some details to be worked out as to how the parties will work together if there's a joint enforcement needed related to the licensed products, at least how they're going to work together with respect to each other, or cooperate, and who's going to bear the costs. Representations and warranties, these are the assurances that each party is going to give each other. We have some examples of representations and warranties that the licensor typically makes on the left-hand side of the slide. I won't read it verbatim, but it's things such as that the licensor owns the mark, that they're not violating any other third-party agreements by way of licensing to the licensee. Licensees typically require at least those basic assurances. Licensee representations and warranties, not always, but they can be typically more robust. And that includes various details about compliance with agreement terms, not engaging in actions that could reasonably be expected to diminish or tarnish the image or reputation of licensed property or cause confusion as to the ownership of the licensed property, compliance with laws, not creating expenses chargeable to licensor without approval, not allowing security interests against the licensed property. Sometimes if you think that you're going to have to take a security interest as a licensee at some point based on because you license a lot of IP and you need a loan, you might want to think about that and how is that going to impact the deal. Sometimes that licensors will absolutely say no, but there may be some opportunity to negotiate that depending on who you're dealing with and the property.
Okay, so we're getting close to switching up, but to just wrap up memorializing the deal, I wanted to talk about some negotiating tips and tricks, some things that I've learned over the years. And really importantly is train your team. Make sure that the business and other lawyers that are non-IP lawyers are trained on what your company your business wants and needs and can do within its licensing policies, whether it's a written policy or it's just the way that they work in licensing. So make sure that your team has a checklist of what are the deal breakers, what is the company's position on different areas of the license agreement, like renewing, minimum royalties that they'll pay, or the guaranteed royalties, how high will they go? If they're the licensee, or the minimum that they'll accept if it's a licensor. And just some standard definitions of like the licensed product. I will commonly, for a business, come up with what is their standard definition for what they do if they do something on a type of license on a regular basis, and have that standard definition that all of the business people know and understand. So we can quickly do our deal points and our deal memo, knowing that we've got our standard definitions already pre-aligned. And then we can tweak them when they need to be tweaked for special deals, for specific deals. If you have company policies, if your company has supplier codes of conduct, or certain policies that a licensor, and I'm speaking from the licensee perspective, but if you have certain policies that the licensor will have their own policies and be insisting in the agreement that the licensee follows the licensor's code of conduct, for example, if you have your own policies, have them available, know what they are, because sometimes you can get the licensor to accept your own policies, corporate policies. And I found that that's been very helpful to speed things up, because there's less review time if the licensor will take your policies. So have those handy and available. And internal communication, I think that it's so helpful that your team communicates internally on a regular basis. I ask the team when we start a new licensing project, I ask the marketing, the business team, to schedule a recurring meeting. And we usually make it a weekly hour meeting. And if we don't need it that week, we cancel it. But just knowing that we have that weekly meeting on calendar helps everybody come together, ask any questions that they have, and make sure that the project is moving forward. Because without that meeting, I find that things can stall and get lost. And sometimes it can become oh, I thought you were doing that, and I thought you were doing that. And so we keep everybody on the team aligned and moving forward. I think external communication with the other side that you're negotiating with is very important. Typically, we have the business people doing the negotiation. That's been my experience. And then the lawyers will jump in where it's needed. But I always suggest to the business people, if we have anything where there's a sticking point, or where there could be some confusion on the edits we're making to an agreement, I say, let's just get on the phone. We can have a business and legal combined call. We can have a legal to legal call. But those calls and getting together with the other side to explain your position helps immensely. And it can really speed things up. And then last thing, I like to keep an issues list. When we get the agreement back from the other side, I like to make an issues list that I can share with my business. It's an internal issues list that we keep just for our side, but it follows the agreement and it tracks the issues and how things were resolved. So if you make a decision, you make a concession, or you make an edit, and then a couple months later, you're still negotiating the agreement, and you're going back, and sometimes I've been scratching my head, well, why did we agree to that? You can go back and look at your issues list, and you can find where you agreed to it, and if you've kept notes on it, why you agreed to it. I found that to be very helpful to track a negotiation that can take several months with a lot of back and forth.
Yes, let's produce. So the contract is signed, and now it's time to produce or get the goods or services, whatever the case may be, onto the market. So the first step is making sure all of the stakeholders on your team know their roles and obligations. You probably have been meeting with them throughout the course of the deal, but making sure to touch base and know what they need to do going forward. Also putting in place mechanisms to track ongoing requirements, deliverables, approvals, deadlines is a good thing to do. Possibly tasking somebody on the team with doing that, maybe relying on technology to help. If you're somebody that you're a licensee or a licensor that has a lot of deals going on, technology can be a help. know what your licensor's audit rights are to make sure that you can keep records and make sure that the people that are supposed to be keeping the records are keeping the correct ones, and doing it in an organized fashion. That's going to make it a lot easier when audit rights come around to be able to just provide the information simply and easily to the licensor. Implement procedures to ensure compliance by manufacturers and other contractors. Make sure everybody knows what they need to do, how they need to use the mark, what they need to comply with in order to not put you as a licensee in breach of the agreement. So here is a best practice. It's great to create a summary of relevant agreement terms for your stakeholders. You can possibly even break that out as to like, these are the ones that are relevant to you, with a master summary that resides somewhere that everybody can access. So everybody can kind of see who's responsible for what and who's doing what. That's something that your lawyers, inside counsel or outside counsel, can help you put together in a usable way. So the end of your licensing term, you've gone through all the cycles, and it's the end of the licensing term is approaching, and you have to make the decision whether to continue the agreement or exit. This typically starts with looking at, first of all, how it's gone, whether you're interested as on both the licensee and the licensor side, and then looking at what the renewal provisions are in the agreement, and whether you can meet those requirements. Looking at if you want to exit, whether you have a sell-off period, and what you need to do to sell the product through, and under what timing, so you can get everybody lined up to make sure that you're going to meet that goal. If you are renewing, consider whether it needs written approval, amendment, some sort of notice. Make sure to calendar all of your notice dates to make sure if you need to provide 6 months notice of renewal, that you're actually able to assess the situation, evaluate, and then make the decision on or before the deadline. If there's any modifications to the agreement that you think you might need, or that you'd like to renegotiate, renewal is a good time to do it. So consider whether there's anything that you absolutely need to change or would like to change, or it might be beneficial to both parties to just revisit. And also consider, what's the desired renewal period? Do you want it to be more long-term, or do you want to reevaluate every year? It's best to consider that upfront, especially if you have something where you know you want 5 more years. There's no point in having to reevaluate every 1 year if you know you want 5. So considering all of those things. Here we have our best practice. Plan for the end up front. Consider your exit strategy at the agreement negotiation stage. Make sure you have an adequate sell-off period. If you're a licensor, make sure that you have the opportunity to get out if you want to get out. If you're a licensee, consider what you need to sell through products or terminate the use of the mark, what if it's in connection with services or other materials, in the event that the agreement terminates or is not renewed. Just make sure that you have appropriate off ramps that work for the team and the business.
Awesome. AI considerations. Okay, so AI is very cool. That's first of all. Let me tell you something. If you don't know about AI, obviously artificial intelligence, if you don't know about it and you're not familiar with it, as a lawyer that's on the call, or anybody that's on the call, you should get yourself familiar with it, because it's only expanding, and the use of it in licensee and licensor and licensing and endorsement, all these things, is just increasing. So let me give you an example, right? Think about the normal Super Bowl commercial. So typically the Super Bowl Bowl's in the end of, the January, February, that time. So essentially what happens is there's the deck a few months before, you shoot the commercial, and then you have the commercial air. Well, technically now what they can do, so let's say Dunkin' Donuts has Ben Affleck this year in the Super Bowl commercial. What they can do is they can actually have Ben Affleck show the Super Bowl commercial and have him throughout the Super Bowl, right, saying relevant things that are happening in the actual game, or talking about another commercial or whatnot. And they can even do more than that. What they can do now is they could say, hey, depending if you're, let's say, a Patriots fan, let's say the Patriots, they're not going to be, but let's say they're playing against the Chiefs in the Super Bowl. Well, if we know and we have data, and we have data that you're a Patriots fan, right? Ben Affleck might be saying one thing in the commercial that you see, and he might be saying something else in the commercial that the Chiefs fans see. So those are some of the new things that are happening, and they're just continuing to grow. And in order to properly, talk to your people and counsel the marketing people how to utilize this technology, these are some of the things that you really should think about. So The first thing is, and this is something that everybody's familiar with, or the first thing you think about, right, is think about the ownership of the material. So typically, right, when it comes to AI, things that are created, right, generated by artificial intelligence are not they're not protectable from an IP perspective, right? As far as, let's say, if the computer or the system invented or created something, typically that's not something that's protected from an IP perspective, right? So think about, and you see here, we say, right, create protectable work. So if there's something here that you're interested in doing, for example, right, you might say, hey, we want to create a new jingle for our ad campaign, right? Well, don't just go to a AI studio that basically takes music and spits it out, because you won't own that, right? So that's not something that you want to do. So you want to think ahead. If it's something that you're going to incorporate into your campaigns, into your licensing schemes or whatnot, you want to really be conscious about how much human authorship do I need to put, to incorporate here in order to create something ownable. That's one thing. Another thing is, people don't necessarily think about it, right? When you have your bots. So in the olden days, right, these bots were just sort of like customer service situations. But nowadays, right, these are things that are going to be on the front line, whether they're handling the marketing effort, the digital marketing effort for a campaign or for any other type of campaign, right? You want to clear the content, right? Because just because an AI said something, it doesn't mean it's okay. It doesn't mean it aligns with what your brand is and whatnot. So make sure you clear it. Make sure you clear it from an IP perspective, obviously, from a right of publicity perspective, but even just from a general content perspective, right? And then another thing about utilizing AI, so what ends up happening is when we talk about models, so people don't really think about it this way, but an AI is not really like a person, right? So it's not creating something. What it is it has a database of things, right? So if it's an entire model or whatnot, or a certain type of system, and you're putting in, let's say you're teaching it what music is. So if you only put in the only hip hop music that it ever had was a Notorious B.I.G. song, then that's its reference. That's what it thinks the music is, right? So it's going to spit out something that sounds like that, right? And the more reference it has, the more it will do. But essentially, it's only going back to what its references are and spitting something out, right? So when you put in information, it's really important to know that whatever you put into that model, it could be spit out. Right. So if there's some type of confidential information, you shouldn't be certain. You should actually be very careful about putting any type of confidential information into any of these models, because it could spit it out, other than the fact that you might be anyways, violating some type of NDAs by putting it in there. Right. So that's something else to think about. And then another thing to think about. So when we talk about these really cool NIL talent agreements that we're talking about, because a lot of the artificial intelligence is going to involve that. You have to really know the way it sits right now, right, of these agreements, other than we'll talk about SAG and whatnot, but these agreements are really heavily reliant on right of publicity and personality right of publicity laws, and they're really different jurisdiction to jurisdiction. So make sure, right, if you're doing an execution, if it's localized or wherever it is, make sure that you understand the impact of whatever the laws are in regards to, utilizing this AI. Okay, next slide.
And just one thing on the ownership piece.
Yeah.
So on the ownership piece, when you're doing a brand licensing deal and say everybody agrees you can use AI and it's sort of at your own risk, you need to make sure, if you're the licensee, that you're not going to be stepping on third-party rights when you use and implement the output of AI. You're responsible for that. But the parties can contract for who between them will own the output. So, and we're talking about like who owns what after, we talked a little bit about that earlier, who owns what after the deal terminates. You might consider that even though, say, nobody owns the copyright in something that an AI submitted or pumped out, the between the parties, either licensee owns it or licensor owns it, and licensee can use it, licensor can use it, so that there's not that confusion. Like, it may be an issue that licensee created something, it was associated with licensor's brand. Now consumers have come to associate that thing with licensor's brand. It doesn't matter who owns it, but licensor doesn't want licensee to use it, or the other way around. So just something to consider, that even though it can't be necessarily owned unless there's some sort of human intervention and it meets certain standards, the parties can still contract for it.
Yeah. Okay. It looks like we jumped, but it's okay. So one of the things you want to know about is that, and again, thinking of how the system works, again, right, when we're talking about the system, so whatever goes into the system, that's what it's spitting out. So if we're talking about voices, or which implicates right of publicity, or we're talking about music, or we're talking about works, right, whatever it's spitting out is based on those references, right? So in the past, when we talked about merely data and analyzing data, because that's what a lot of the AI did in the past, when we're not talking about generative AI, it does the training of that data and the strength of a copyrighted fair use defense is pretty strong, and companies, big companies, AI companies, pretty much ignored any risk, and the companies contracting with them pretty much ignored any risk. However, now that we're moving to generative AI stuff, right, and that's a lot of the things that are going to be going on in the licensing world, right, that risk is extremely heightened for a couple reasons. One, again, because whatever you put in, that's what it's spitting out. So if we talk about music, right, the music, as we've seen in the past few years with some music copyright infringement cases, right, the music that it spits out, if it's referencing certain music, it might really be substantially similar. As far as voices, there's a big trend in lawsuits talking about voices, right, where people are claiming that their voice was utilized and the voice that's the output sounds like their voice. So it's very important, and we'll use a best practice here, it's very important to look for indemnity and whatnot. I just want to go through a couple of these quickly. So when we talk about AI, right, again, right of publicity is the main thing. Even though, right, you might be tempted to say, hey, our brand people only want to mimic the voice of a certain celebrity, but we're not mentioning the name, we're not showing the picture of them. Well, it's pretty established law, right? Aside from other stuff going on, it's pretty established law that, like in California for sure, in the Ninth Circuit, where a lot of these things are happening, impersonators, things that evoke, right, the publicity of certain people, right, that's actionable. So don't think you could just use someone's voice, right? If you're mimicking a voice or whatnot, that is probably going to lead to a right of publicity claim, and celebrities are very litigious with this kind of stuff. One thing I will tell you, and this is important, right? So if you look at the trends are that it's extremely important to specify the use of AI. So us as lawyers, we like to think, look, we're generally familiar with right of publicity or IP, and if we draft it broadly, like, we'll capture everything. So in the world that used to exist, that's okay, that's a fine approach, and absent anything else, that's a fine approach. The issue is that the trend is becoming, whether it be new, let's say, California laws that are passing, or whether it be this SAG-AFTRA, you need informed consent of the actual use that you're using it in for AI purposes or whatnot, digital replicas. And you might need it in separate writing, or at least like initial in the agreement itself, right? It's not going to be enough how we used to do whatever it is, right? So those are a couple of things to think about, right? And make sure to keep current, because the laws are changing constantly. And when we talk about a new regime, whether it be the Copyright Office's recommendations or deepfake laws, right, that's going to change the concept of what right of publicity was, where it was like a human trademark concept, right, where commercial use, and it's going to move to a different type of regime, which is less intuitive, and it's not really going to be depend on how commercially you use it, right? So next slide, maybe let's see if we can talk
Todd,
about.
I was going to say we probably should jump to the cases now, because we
great.
have 2 minutes left before everyone will be leaving us.
Awesome. Okay, cool.
So 1 minute on each case, and then we'll close up.
1 minute. I'll try my best to talk 1 minute about this case. Okay, so we can learn a really important lesson in this case. I was involved in this case. Now, essentially, what happened was, you heard of Modelo. You've heard of Corona, right? You've heard of Corona, and you've heard of Constellation. Well, Modelo owns the trademark for Corona, and even in the U.S., in the world, throughout the world. And what happens is, in the U.S., there's a license to sell. So Constellation has a license basically to sell Corona. So when you go buy a Corona in the U.S., even though Modelo owns the trademark, essentially you're buying a Constellation product, right? So in the agreement, right, there was a license for beer. That was the concept. That's what it was. What it entailed. Now, in the agreement, there was a specific definition of beer, and the definition of beer largely tracked what the regulatory definition is. The issue became that hard seltzers came along. They didn't exist in the beginning. When the agreement started, they didn't exist, right? So what ended up happening, there was a big fight whether the definition of beer included hard seltzers or not, even because they were not malt-based. It was not necessarily a beer in that sense. And essentially, Constellation won the lawsuit and the appeal, and they're able to sell this seltzer. Now, this is really important. So you want to be able to really be clear about what the licensed products are. And you also want to keep an eye on the future to try to understand, what products are going to be in the future to make sure you're retaining the rights. So one more minute. Christine, sorry.
Yeah, no, that's awesome. So I'll just say, if anyone has to drop off, thank you for joining us. We probably have 2 or 3 minutes that we'll go over if you want to stay on and hear about the final case to watch.
Yeah, so this one is it's a case to watch. It's maybe the most watched case currently in brand licensing. Pennsylvania State v. Vintage Brand. Here, Vintage Brand is selling clothing with the Penn State lion logo on its website and basically through its website, its online portal. There was a disclaimer printed that Vintage designs are not affiliated with or licensed or sponsored by any college team or league. So Vintage trying to disclaim that they don't have a license and that they don't own the mark. And there's a question. So Penn State brings a lawsuit saying you're infringing our trademark. You don't have permission. This is a mark that we license to others. You don't have a license. You can't use it. Vintage sort of turned that argument on its head, looking at USPTO refusals, where the USPTO, it's a common refusal when you're dealing with merchandise like this and trademarks, where the trademark is displayed on, let's say, the front of a T-shirt, that they will issue a refusal saying that the use is not trademark use, it's merely ornamental. So that's what Vintage is arguing. They're saying this use is not trademark use. Nobody thinks we're affiliated with you or licensed by you. It's merely ornamental. And filed a motion to dismiss, which was denied. So this is going through the court system now, and depending on how the court comes out, this could have some significant impact for both licensors and licensees in terms of what you can license, in terms of how you can monetize your mark, and what you can prevent other parties from doing. So case to watch when the decision comes down. We'll have an update, maybe even a whole discussion or webinar about it. So just stay tuned, and more to come on this. Very interesting case.
We thank everybody for being in the audience and listening. And if anyone has any questions, wants to discuss anything we've talked about or anything related to brand licensing or AI, don't hesitate to contact us. You'll be getting an email with our information, these slides, the survey, and some other materials from us soon.
Yeah, and if you
Thank
put a
you.
question in the chat, I think I just see one question in the chat. I will send a separate message answering that question. But we have a question, and I know we're a little bit over, so I'm not sure who's still with us. But the question is, do most licensees use any technology to keep track of the design proofs and product approvals? The answer is, some do, some don't. It's not most. We tend to find that those that have a lot of license deals in place, whether on the licensee or the licensor side, may rely on technology to track. Others that only have a few do not. Maybe it's just a calendaring or a person that's in charge. So it really just depends on the technology available to the organization and the volume.
All right. Thank you, everyone.
Thank you, everybody.